Bismillahirrahmanirrahim. Dear fellows, today I deliver lecture number 10 on Companies Act 2017. In this lecture, I discuss about the prospectus, allotment, issue, and transfer of shares and other securities. So the part 5 of Companies Act 2017 deals with this subject matter. First of all, I start with prospectus. Section 57 of Companies Act deals with prospectus. First of all, we need to understand that what are the prerequisites need to be observed before the issuance of the prospectus. So the subsection 1 of section 57 envisages that the prospectus shall not be issued on or before the date of its publication unless a copy signed by every person who is named as director or a proposed director has been filed with the registrar. So it is truly classified under the provision of subsection 1 of section 57 that the copy of the prospectus need to be filed with the registrar by the management of the company. And what are the post consequences in those cases if the violation is committed by the management of the company in this behalf? In case if the contravention of this section is committed, the company and every person who is a party to the issue, prospectus or circulation of the prospectus shall be liable to a penalty not exceeding level 2 on the standard scale. So the penal consequences are also provided under subsection 2. So how it can be avoided? The company can only avoid these penal consequences by filing the prospectus which is signed by the person who is named as the director or a proposed director with the registrar within the stipulated time period. Now we move ahead towards section 58. The head of section 58 is classes and kinds of share capital. So we have different classes of the share capital and with its different kind. And how the company can deal with this share capital, it is narrated under subsection 1 that the company is authorized to issue only fully paid shares and those shares may be of different kind. So here the binding effect is given under the provisions of subsection 1 which direct the management of the company to issue only those shares which are fully paid. So no provision under the Companies Act 2017 authorizes the management to make any transaction in respect of unpaid shares. So now we move towards the proviso of section 58, which provides that the different rights and privileges are regulated by the law with respect to the kind and class of the shares. So it is not a very hard and fast rule against each and every share. We need to observe specific provisions as stated under the law with respect to the nature and kind of the share. Now the next and the final topic which we have to discuss today is variation of the shareholders' right. This topic is very important, having its own significance, and section 59 is the relevant section deals with it. Subsection 1 provides that the variation of the right of shareholders of any class shall be effected only in the manner as laid down in section 38. So the right of any shareholder of the company can only be varied with respect to the provisions as stated under section 38. And what is section 38? Section 38 deals with alteration in the articles of the company. And how this alteration can be done? It can be done by passing a resolution. So for a time being, we say that the resolution is brought forth by the management of the company in which the right of the shareholder is affected. Then what are the provisions given under the Companies Act 2017 for the redressal of grievance of any shareholder's right? So subsection 2 provides that the person having more than 10% of the class of shareholder may within 30 days of the passing of resolution apply to the court for its cancellation. So the time limit is given to the shareholders having more than 10% of the shareholding rights to apply to the court for its cancellation. And how the process of cancellation can be construed under the law. Further proviso of subsection 2 classifies that the cancellation of the resolution is subject to the satisfaction of the court. And how the court can be satisfied? That either the variation prejudiced the shareholder's right or not. So the court has to go into the depth of this matter in order to examine the true sanctity of the right of the shareholder and its preservation in all four corners. And if the order is passed by the court, then what are its post consequences and how it incurs the liability, the responsibility of the company in this regard. So once the order is passed and it is communicated to the company, then the company within 15 days of the receipt of the order from the court shall communicate it to the registrar, and in those cases, if such correspondence is not done, then the defaulter shall be liable to the penalty not exceeding of level 1 on the standard scale. So the complete procedural requirements are given under section 59 in those cases where the right of the shareholder is varied and where it is affected. So dear fellows, I conclude this here by saying that today we have discussed prospectus, classes and kinds of share capital, and what are the procedural requirements with respect to the nature of the share capital. And thirdly, we discuss the variation of the shareholder's right. So when the shareholder right is varied, then what are the provisions stated under the law in order to procure and preserve the right of the shareholders. So I hope that you learned a lot from this lecture number 10. In case of any further query, you may call anytime. A number is given aside. Thank you very much. Keep in touch with me. Stay blessed, dears. Allah Hafiz.